The major piece of legislation that we'll focus on is the congressional legislation having to do with the Securities Act of 1933, the Securities and Exchange Act of 1934, the Investment Companies Act of 1940, the Investment Advisors Act of 1940, and the Sarbanes-Oxley. These are part of what is referred to as the U.S. Code. Under SEC rules, we will review Rule 147, Rule 505, and Rule 506. So is everyone here familiar with the difference between the U.S. Code and the U.S. Code of Federal Regulations? Okay. The U.S. Code is basically a book or a document which contains all the laws that are passed by Congress. The U.S. Code of Federal Regulations is basically, well, now it's a database, but in the old days it was a physical book, which were all the regulations passed by the White House or agencies like the SEC that report to the White House. As a matter of constitutional law in the United States, the law passed by Congress trumps a regulation passed by a branch of the executive. However, generally when a law is passed by Congress, it's made broad, principles are generally stated, and the specifics are left to the White House to implement through regulations. If Congress ever feels like the White House has gone astray, or if the White House or an agency ever comes back to Congress and says, look, we really don't have enough guidance here, then Congress will pass a new law. Okay? So these are the broad topics that we'll cover in Topic 1, Rules and Regulations. Okay? We'll start off with just going through an overview of private equity, just so we can sort of get our bearings here. There's a very good document written. It was the Committee on, I'm sorry, would you mind just closing that door so we don't get so much noise? It was a very good report written, Committee on Capital Markets Regulation, and what it did was went through the impact of Sarbanes-Oxley. And as you may know, a lot of people have complained about the impact of Sarbanes-Oxley on the public markets, and they came up with some very interesting statistics. Number one is that the U.S. share of the global IPO market, meaning if you go out there and you take a look at all the monies raised through IPOs, all right, the U.S. used to have half of that market. So half of the money raised in IPOs used to be in IPOs taking place on the New York Stock Exchange or NASDAQ, and that after Sarbanes-Oxley it dropped to 5%. Okay, a pretty severe impact. Okay. There are other ways of looking at it. You can take a look at all equity capital raised. The U.S. share of that market has not dropped as far, from 41% down to 28%. That's probably because a lot of companies that are already public in the United States can't get unpublic. This is another unique feature of the United States equity markets, is because the SEC was set up to protect investors. Once you've registered with the SEC, it's very hard to become unregistered. So you would expect that the amount of capital raised in follow-on offerings would not be impacted as much, but it's still impacted because there are fewer companies that are going public. If there are fewer companies that are going public with the same number of companies being created, that means more private companies around. Okay? If you take a look on the asset side, private equity firms that were almost non-existent 25 years ago, they had $200 billion worth of capital formation. This report came out at the end of 2006, so what it says last year, that was 2005. And $200 billion is a lot of money. The report goes on to state there's actually more money now flowing into private equity funds than there is flowing into public equity funds or mutual funds. So there has been a real sea change in the marketplace, and a lot of people, you know, they kind of shake their head. And this is a classic example, critics will say, of Washington trying to do a good thing and ending up causing more problems than they solved, right? So if you make it more expensive to be public, which is obviously not the intent, what they want to do is protect the investor. But if you protect the investor by creating rules and regulations that are costly to comply with and risky, Sarbanes-Oxley will put a big liability on the CEO and the CFO. The market adjusts, and perhaps not the way that legislators were hoping for. So anyways, I would encourage all of you to take a look at this. It's a very good report. It's easy to access. You just Google it, Committee on Capital Markets Regulation, and it's a very large report. I encourage you to go through there. It's a very detailed reading as to how a piece of legislation that was designed to clean up the equity capital markets has done that, but it's also reduced the size of the public portion of the marketplace. So we go on there to talk about the definition of an equity security. If you're going to talk about private equity, let's talk about, first of all, what equity is. And there are a couple of different ways of approaching this. The first one is you can look at one of those early pieces of what I would refer to as enabling legislation. If you take a look at the Securities Exchange Act of 1934, you'll see that they have a long, drawn-out definition of what an equity security is. This is how things start off in Washington, is you have some poor congressional staffer sit there and write out long definitions of what something is, and he talks to experts, and he talks to his buddies, and he talks to the other staffers, and you get this long, drawn-out explanation as to what an equity security is. And then, of course, it faces the court tests, right? The regulators try to enforce that definition. The marketplace doesn't like it. Somebody gets sued, somebody countersues, and it ends up in court. So with the definition of equity security, we did end up in court, went all the way up to the Supreme Court, and what we got was the Howey decision in 1946, which enacted a four-part test for what defines an equity security. And that four-part test is that it involves the investment of money, okay? It involves the expectation of a profit, and it involves a common enterprise, and it depends on the efforts of a third party, okay? So let's test that out. If you were to take, for example, does anyone have an organization that we might test that out with? Somebody throw out a name. How about something like the New York Yacht Club? Okay, the New York Yacht Club did have an investment of money. They have assets. Okay, so they had to raise capital in order to get those assets. There's not, I do not believe, an expectation of a profit at the New York Yacht Club, so that would not satisfy the definition. Let's take a Yale University. Okay, so Yale University obviously has assets, right? So there was an investment of money. Somebody had to give them the money so they can build those. Is there an expectation of profits at Yale? Yes. Okay. Is it a common enterprise? Many people working together towards one goal, right? Okay. And does it depend on the efforts of a third party? This would be delineation between a partnership and a corporation. If you think, for example, of a law firm, okay? There you have a common enterprise, right? But it's the partners themselves that are running it. There's no management team, okay? So I would say with Yale, there's a precedent of Yale, right? So it depends upon a third party. Okay? Let's just imagine ourselves putting together, we talk about flying, so let's say we put together a helicopter company. Okay? Does that involve the investment of money? You have to have a helicopter, right? So somebody had to put in the initial money, $400,000 to buy a helicopter, okay? R-44. Okay? Is there an expectation of a profit? Well, you never make much money in flying, but sure, you can go into that hoping to make some money. All right? Is it a common enterprise? Well, if you and I are running it together, that's a common enterprise. We have a common expectation in making the profit. And does it depend on the efforts of a third party? Well, if it ends up being you and I running the business, all right, you fly the helicopter one day with a student, the next day the student flies with me, the third day he flies with you again, there's no third party that's running that. Now, if you're the instructor, or you're the pilot that flies the helicopter, goes off and does photo shoots, takes people out to the Hamptons, and I'm the management that reviews your business and makes the decisions about allocation of costs and all the rest of this, well, then that would depend upon the efforts of a third party, okay? Unless I owned all the equity, in which case there wouldn't be a third party, I'd just be protecting my investment. So these are the types of tests that the Supreme Court came up with. And it was important because the lawsuit here originated because the SEC said that they were in a position to regulate this individual, and the individual in the Howey case